5 seconds. Start. Being aggrieved by and dissatisfied with the judgment of conviction and the order of sentence, the petitioner, along with his mother and two sisters, preferred criminal appeal number 295 of 2010, in which the learned appeal court wide judgment dated 30/4/2013, passed by the learned additional sessions judge Gatsila, confirmed the conviction and sentence of the petitioner for the offence under section 498A of the Indian Penal Code only, but set aside the conviction and sentence of the petitioner under sections 3 and 4 of the Dowry Prohibition Act, and also set aside the order directing the petitioner to pay compensation of rupees 2 lakhs to the informant, and partly allowed the criminal appeal with respect to the petitioner. The learned appeal court also set aside the conviction and sentence of the mother and two sisters of the petitioner. Arguments on behalf of the petitioner. The learned counsel appearing for the petitioner submitted that the petitioner is the husband of the informant, and his conviction under section 498A of the Indian Penal Code has been confirmed by the learned appellate court by recording specific findings at para 32 of its judgment. He further submitted that the learned appellate court has recorded that the prosecution has been able to prove the allegation of subjecting the informant to cruelty by the husband, and such allegation was supported by evidence of the informant PW7 read with the evidence of PW4, PW5 and PW6, who have supported the evidences of one another that husband used to assault the informant. The learned counsel submitted that the learned appeal court wide para 31 read with para 13 and 35 of its judgment has held that neither the demand of dowry was proved nor the accused could be convicted under section 4 of the Dowry Prohibition Act 1961. Learned counsel further submitted that as the demand of property was not proved, the cruelty has to be seen in the light of explanation A of section 498A of Indian Penal Code. He also submitted that all assault may not come within the meaning of cruelty under explanation A of section 498A of Indian Penal Code, but the same is required to be of such a nature as is likely to drive the woman to commit suicide or to cause grave injury or danger to life, limb or health, whether mental or physical, of the woman, and for that purpose also evidence was required to be led. Learned counsel submitted that the learned appellate court wide para 32 has convicted the petitioner under section 498A of Indian Penal Code by holding that the petitioner has not managed to keep and maintain his wife properly and has not taken any step since long for treatment of her mental ailment, and such omission and commission alleged and proved against the petitioner are sufficient for a deserted wife to commit any act dangerous to her life. He submitted that there is no allegation on record that the wife was subjected to any cruelty of the nature contemplated under explanation A of section 498A of Indian Penal Code. He further submitted that the finding of the learned appeal court that since long the petitioner has not taken any steps for treatment of his wife is also contrary to the impugned judgment of the learned appellate court in para 21, wherein the deposition of the informant has been recorded where she clearly deposed that her treatment took place continuously for 15 to 16 days in the private mental hospital Ranchi, and during her treatment her father and her husband both were with her. He also submitted that it has also come in evidence that at the time of marriage itself the mental condition of the informant was not sound. Learned counsel also submitted that not only there is total absence of evidence on record to bring home the basic ingredients of cruelty as contemplated under explanation A of section 498A of Indian Penal Code, but also the prosecution had filed such evidences which were discarded by the learned appellate court by citing reasons. He submitted that the learned appellate court has recorded finding in connection with such prosecution evidences which were brought before the learned court below by way of afterthought, and the learned appellate court rejected those evidences by speaking order. Learned counsel for the petitioner also submitted that, considering the other findings recorded by the learned appellate court, the present case is a fit case where the learned appeal court should have granted benefit of doubt to the petitioner, as the veracity of the prosecution evidence and the manner in which it was produced before the learned trial court itself created a doubt in the prosecution case. Learned counsel for the petitioner also relied upon the statement of the petitioner recorded under section 313 of Code of Criminal Procedure to submit that only vague questions were put to him by the learned trial court while recording statement under section 313 of CRPC. That's all.